the cases and stuff too. Also questions in the chat about XRP and maybe we'll get into Coinbase and that stuff too. But PulseChain, Hex, Richard Hart, you want to just maybe a quick recap of this tweet? I think it encapsulates it pretty well too about the allegations and the case and stuff. You want to just hit some highlights on this one?
Oh, sure. Yeah. The only reason, again, this goes back to what I said a little bit earlier. Richard Hart isn't accused of violating any crypto regulations because there are none from the SEC. He's accused of violating securities law, right? And the only securities law that they're talking about is Howey. So, if the only basis for their entire lawsuit is we think you violated Howey, which encompasses like registration, you have to disclose or you can't omit certain things or whatever. And that's the reason why they're going after him for the 12 million or whatever that he spent. It has to do with, not disclosing that information to the investing public under Rule 10b-5 or whatever. So it has nothing to do with actual fraud. It just has to do with securities, defrauding people who were, thinking that you were going to do something else with that money or that they were sending it to you to build this project or whatever nonsense. But it's the fraud that they're alleging is in connection with the offering or sale of a security. The only reason that the case exists is because they think it violated securities law. So if you're going to change the rules on how you analyze crypto cases from now on, and it's not simply Howey or not Howey, because that's what we've had. We've had a light switch with the SEC. It's either yes, it violates Howey, or no, it doesn't violate Howey. If it violates Howey, they automatically sue you for whatever the hell. And but if you can't get to step 2 and say, oh, there was an omission or in your failure to make your white paper or your registration documents or whatever that you left out, if the light switch doesn't go on, right? It's not Howey. You can't get there from there. You can't. Saying you committed fraud in connection with the sale of a security only works if there was a security that you could have sold, right? You can't be in trouble for doing all the things that he did unless there's a security at the other end of it. So I guess that's the point I was trying to make there is you can't do the second step first. You have to basically say, you have to look at it now saying, are we going to consider crypto asset securities just because we think they failed Howey, or is there going to be some completely different way that we analyze these things? And from that executive order and from David Sachs's comments, there is going to be a completely different way that we analyze these things. And it has, there may be elements of Howey incorporated into it, but it is not going to be a on-off Howey or not Howey light switch from now on.
Howey has really been this crutch that they've been leaning on for so long. And in my personal opinion, I think in the Richard Hart case, they absolutely abused the hell out of it too. If you go look at the SEC response to the Richard Hart case, their explanation of Howey, which Howey's not alleged in the motion to dismiss here, by the way, but the SEC is the one that invokes it and brings it up. They actually go through the 4 prongs and they're like, yeah, it probably doesn't violate any of the prongs. But if you look at the totality of the circumstances, there's like so many people here that made money that it has to be them making money by other people's efforts. And it's just like, cool, you just read that into existence out of just your imagination and whole cloth. Like that, we had a very specific test for Howey. You went through the test and then added your own steps because you wanted to.
Yeah.
That's the kind of stuff that makes people feel like they're taking crazy pills.
Yep. And, I'm not sure that they were completely enthused about their own case at the hearing. They didn't.
Oh, yeah. When you have the Richard Hart legal team that is because remember, folks, what we had was the hearing on the motion to dismiss. So part of this, they're not arguing over the merits of the facts themselves. The SEC, again, brought up the Howey test, and then Richard Hart's legal team kind of like sat up and goes, we're not here to discuss that, but we are more than prepared to talk about Howey in this case. And it was like these guys are chomping at the bit to take Howey down because they see all the holes and they see that it has become just flimsy.
Yeah, that's why I'm 100% like not 100% because I'm never 100%, but I'm very, very, very confident that the SEC doesn't have a real path to victory on Howey in Richard's case, even if they do get past the motion to dismiss. I just don't see a way there. You know, I can only imagine that they've thrown out, you know, settlement offers over and over again, the Richards team, and they've been told to go fuck themselves over and over and over again. I mean, just how about, you know, just give us a coupon for great clips, and then we'll call it a day. But you have to sign this non-disclosure, you know, the shut up
future muzzling. I can't see that happening either.
I just don't see it. Yeah, I think he's there. If he wanted to go that route again, he could have done it with one good team. You know, he didn't need everybody.
Didn't need the.
You all haven't seen the all-star of all-star. Like that's a squad.
Yeah.
If you all haven't seen, just for anyone who haven't read the motion to dismiss, I read it fully, printed it out, loved it. Great, especially if you're you know, you need some just afternoon reading, or you're on an airplane, or you just like want to go through the winning that is written in this document. Super good. Came out last year. Basically destroys all the different claims, all that stuff too, which I want to tie back to on this one. So in the tweet here, you say too, for one reason only, they're securities. If not, then none of the allegations in the complaint could have been brought. I mean, again, we talked about this before on the show. The strongest ones are listed here, kind of in descending order. Is this literally with the recent developments and stuff and SEC and the stuff with Davis Sachs and all that stuff too, how much does this increase the chances of the personal jurisdiction, like us winning that for the dismissal?
It actually doesn't change the personal jurisdiction analysis, since personal jurisdiction has been enshrined in U.S. Supreme Court case law since like the 40s with International Shoe and Worldwide Volkswagen and, you know, a number of other cases. So what the issues that she's analyzing right now are not going to be changed at all by the new administration, because that law is set in stone. It's not going to change. It's just how the facts of each individual case determine how that law is going to be applied. And the SEC really didn't have the answers that the court was looking for. You know, what we have here is we have one anonymous guy in Eastern District of New York, possibly
one guy in Brooklyn,
who may have bought Hex because he couldn't possibly have bought Pulse or PulseX on Uniswap. And you know, we have Richard, who's doing all this stuff in Europe, and you know, it's very clear law. I mean, all of his meetups were in person, were in Europe. Everything he did was in Europe. Yes, he's talked a lot on stream, but that has nothing to do. Like, there's plenty of case law out there that says, you know, just talking on a video that's available to the world is not specifically targeting U.S. citizens. You know, the SEC. One of my favorite parts of that argument, that oral argument in New York, was the SEC kept trying to rely on FlexScore, because FlexScore was a case that was decided by Judge Amon on personal jurisdiction. And at one point, she basically said, this case is vastly different than FlexScore. Like, shut up. I don't want to hear it. It doesn't apply. Like, and if that's the best you've got, you know, maybe your case ain't great. So, you know, so I don't know, man. I'm still thinking that, you know, this is a far better than average personal jurisdiction case, motion to dismiss. You know, most of them are just nonsense. This one just has some real teeth to it, and I hope we see what I think could happen here.
By the way, real quick, this is one of my favorite tweets that you put out recently. This is the spicy herbs, if you will. The second paragraph we have, at first glance, I'm not sure I agree that this means the SEC has to dump the case against Richard Hart immediately. Although it does appear that the SEC odds of winning their case appear to have gone from slim to much slimmer. If their chances were 2020 Ariana Grande before, their chances are 2025 Ariana Grande now.
Yeah, that's what you get after a glass of wine or two. Yeah.
Shout out to Ariana Grande.
I was dying laughing when I saw that.
I'm not sure this is good or bad for her, but she's, you know, she could be a Trump supporter. You never know. She could be on the side of, she could be, that would be funny. Now cue the AI MAGA hat on top of Ariana Grande.
There you go.
That would be pretty funny. Regardless of her, though, why Herbs Dev? Why this? Why this mean that?
Why? Again, we're not going to analyze things under Howey anymore, right? It's not going to be a light switch like where it's Howey or not Howey. I think we're going to, our new administration is recognizing that there are a ton of different utilities to crypto. There's a ton of different types of coins. It's not a one size fits all everything. It's a security. So I think, that's the old way that SEC was able to argue these cases, and for the most part, win a bunch of them. And yes, they put people out of business, and that's how they won, or they forced people to settle, and that's how they won. But that analysis was still the same, from their complaints in those days to the complaint in Richard's case. Once that analysis doesn't apply anymore, because we have new legislation, new whatever, and I'll say this too, like if the judge allows this case to move forward in part, I can't imagine it moving forward in the whole thing, but I mean, if she does allow it to move forward in some way, shape, or form, if I were Richard's team, I might seriously consider filing a motion to stay the proceedings if the SEC doesn't, and just say, hey, listen, we don't even know if this is going to be applying. We don't even know if the SEC is going to have authority over this type of case in a couple of months. We can't, we're not going to get through, discovery and whatever, and why are you going to put my client through the expense of discovery, depositions, everything else, and all this stuff like that. And then we find out 6 months later that the SEC doesn't even have the authority to bring this case. So, it might be a worthwhile argument from both sides. The SEC probably should do it, and say, hey, listen, we don't know if we're going to be in control of this type of case in the next 6 months. But, Richard's team also has a valid argument. I mean, this could be, in theory, I mean, it could be a joint motion where both sides are asking for it. So I don't know. I like it.
So I guess here's a question for you is
Sure.
that allegedly this Trump administration, we get some actual legislation passed, signed, and in effect that helps regulate crypto in a slightly different way, or actually kind of hems in the power of the SEC. Would something like that hurt a pre-existing case? Is that something that a court would take into consideration and be like, hey, we just passed this law, we just don't want to prosecute this anymore?
Yeah, you can do that. I mean, let's take any other case where
I guess I'm imagining a case similar to back when a lot of states started legalizing marijuana.
That's where I was going to go with that. That's exactly where I was going to go with that. Where the law changed and a bunch of prosecutions had to get dropped. That's kind of the way things work. I mean, you can't prosecute for something that's not really illegal anymore. If why not put that in front of a jury? Because the jury's going to just not, even if they wanted to move forward with it, it's relatively silly to do so, right? I mean, it's legal now. So
I would agree. The reason that I bring that up is because I think that it's very clear that the pendulum has shifted. The winds have changed. Things are very much in pro crypto standpoints at this time. Whether it's court rulings, whether it's all the stuff that the Trump administration is doing, which I think is fantastic. I think that the amount of wins have been stacking up on the side of crypto, and that the best thing Gary Gensler ever did for crypto was try suing everybody and losing, because he absolutely tanked their win percentage and started creating good precedent against their arguments. So, Max, if you don't mind, I want to bring this up. I probably have done it in the past, but I think it's a very important one.
Let's do it.
So we are looking at the Van Loon case that is coming out of the Fifth Circuit. This is out of Texas, I believe. This happened in November, December-ish. What this was the most unlikely of candidates to actually get a win over the federal government, which was people in support of Tornado Cash. Yes, that thing that the U.S. government hates the most, crypto mixers, used by that North Korean group, the Lazarus Group, to funnel stolen funds. Yeah, those people beat the federal government. And the reason that they did it is because they actually proved it in court, the thing that we've been talking about this stream, which is that the U.S. government is trying to apply old bad laws and regulations to a new asset class that just does not apply. So I'm going to read here real quick. This is the final page talking about the decision. So we readily recognize the real-world downsides of certain uncontrollable technology failing outside of OFAC's sanctioning authority. Oh gosh, what is the Office of Foreign Adversary Control or something?
Control, something like that. Yeah, asset control.
Pretty much, it's a group that's charged with, hey, make sure other countries aren't like messing with us financially. It's like, okay, cool. Presidential administrations are rightly concerned with malicious cyber-enabled activities, and the IEEPA, the Enabling Act, became law in 1977, years before the modern internet was even invented. But we must uphold the statutory bargain struck or misstruck by Congress, not tinker with it. Quote, the foremost task of legal interpretation is divining what the law is, not what the judge-interpreter wishes it to be. IEEPA grants the president broad powers to regulate a variety of economic transactions, but its language is not limitless. Mending a statute's blind spots or smoothing its disruptive effects falls outside of our lane. We decline the department's invitation to judicial lawmaking. Revising Congress's handiwork under the guise of interpreting. Legislating is Congress's job and Congress's alone. Accordingly, we reverse and remand the district court decision and instructions to grant Van Loon's partial motion for summary judgment based on the Administrative Procedures Act. So, translation. Your laws don't apply to the thing you're trying to apply them to. If you want to apply it, you got to go pass better laws.
Yep, this is exactly what happens in way too many cases. Because as I like to tell people, tech moves fast, law moves slow. And when you get creative, like you get somebody, let's say, I don't know, a Gary Gensler type or SEC lawyers or whatever, and you get a directive and you say, how can we go want to exist? And they look and say, what law is available that and Howey was an umbrella designed to cover certain investment contracts. And what they said was, we can stretch that umbrella to cover these other things as well. Let's see if it works in court. And again, because you don't have the penalty of paying somebody's attorney's fees if you lose, you get to do this over and over again and over again on the government's dime and just bankrupt people on the other side. So that's why you get wins from the SEC on a lot of these things. And you have Howey that's kind of stretched to the point where it's basically unrecognizable to cover a bunch of projects, crypto things that it was never meant to cover. So this is exactly what they did with the Tornado Cash ruling as well. They tried to say, well, this statute or this enabling act gave us the authority to pull this umbrella over Tornado Cash. And the judges said, no, this is not, you want this to cover it, you go back and ask Congress for it. So,
that's true. To get even more granular with it, if you look at the first paragraph here, it actually covers the core issue, which is saying our Constitution's ingenious design demands that judges be sticklers when it comes to decoding legislative text. Because these immutable smart contracts are not property under the words common or ordinary meaning or under OFAC definitions, we hold that OFAC exceeded its statutory authority. Pretty much what it's saying is that the statutes on hand state that they are able to regulate property. They are trying to determine whether an immutable smart contract is property, and as they actually discuss in this document, this is only 34 pages. It's not too terrible of a read, actually. They have really good graphics, too, describing the Tornado Cash process. What they're saying is, look, they've rescinded the admin keys. No one is in control of this. Property demands that there is an owner to it. If nobody owns this, it's no longer property. And that is an important part of immutable smart contracts, which is that there are no administrative controls. So because of that, this is a new asset class that does actually fall outside of your old regulatory authority.
Yeah, and this is where I caution everybody to read the definition section of any legislation, because you can define, and I talked about this in a PulseChain Law School thing months ago, where you can define, Congress can define anything they want to in any way, and the courts are stuck with that interpretation. I think I used the apple and a banana, like, an apple is a yellow fruit curved or whatever like that. And that's what the courts are stuck with, because that applies in that particular law. And you can define an apple 100 different ways in 100 different laws, but when you sue under that law, or when you're being sued under that law, that particular definition applies to that lawsuit, even if a definition is entirely different and would have helped you in a different law. So you have to be really careful in the definition section when you write these things out, or you over include or under include, and you can't really blame anybody with an OFAC here, because this is technology that didn't exist. The problem is that they didn't update it. It's their own goddamn fault. Like, the government is lazy for the most part and does not when they recognize a problem, the simplest thing to do is go, hey, we need to redefine, our term. Let's put it out there, pursuant to the APA, and do our notice and comment period and all this other nonsense that you got to do. But they're like, fuck it, we'll just try it in court. And that's when you just try to get the courts to do something, especially the Fifth Circuit these days. Like you want them to go out of bounds. They're not going. They're not going to follow you down the road that you want to take them, because it's not the right thing to do.
Hey, one of the pushbacks that I'm going to get for bringing up this one is, cool, you brought up a circuit court decision. How does that affect everybody? Would a circuit court go through the trouble of all of this if they believe it's just going to get struck down by the Supreme Court?
No, circuit courts write their decisions for the Supreme Court, because they know that eventually there's going to be a split in the circuit, and they want their rationale to be looked at more favorably by the Supremes. That's it. Like,
there you go. The reason, final point on this, the reason I bring it up is that this is one more grain of sand in the growing heap of wins that are pushing in favor of crypto and against the overwhelming power of the regulatory state, in my personal opinion. And yes, Max, like Max brought up earlier, this case was only possible because Chevron deference was overturned. That has been a key factor in fighting back in the court system. There is a great irony now, which is now that Chevron deference is overturned, you can, again, sue governments over their interpretation of statutes. So theoretically, it does open up President Trump to having some of the executive orders sued over that regard. But at the same time, it just seems that this is just continuing the pendulum shift, and it is clearly going a certain direction.
Stars are mostly aligned. I like it. I'll take it.